First of all, I want to thank Robert and Kevin for coming back here for the 900th time. But you know what? You guys are such an unbelievable well of information, and it's a well that never runs dry. So thank you both for coming here today. Today's CLE is something you guys both know a whole lot about, and we're going to call it ARBIT. You know why we're calling it ARBIT? Because I've heard you say that a million times. And then decided we're going to go, and I'm going to ARBIT, you know. I don't know what that means, but it sounds pretty cool, you know. When you say you're going to ARB something, what's that mean?
Well, in terms of arbitration, there's two types. There's through the court, where there's court-mandated or required arbitration of all personal injury cases. Mm-hmm. And then there is several different types. There's also arbitration in the underinsured and uninsured motorist context, where certain policies require it or have it as an option, as a way to initially try to resolve a underinsured motorist or a uninsured motorist claim.
All right, now you have to start with the proposition. I know zero about this, okay? I don't say anything without my lawyer here, okay? So Kevin, you watch for me. Don't let me confess. Problem. Okay. I want to talk about, first of all, am I correct in assuming that a lot of this comes from ACRA? I mean, this is all stuff that was implemented by ACRA. I know there was arbitration before that, but is arbitration different now because of ACRA?
Well, there is, in the ACRA context, there is mandatory arbitration of all personal injury protection, or the no-fault benefits aspect of it.
Okay.
The UM and UIM, or the uninsured and underinsured,
right,
is not necessarily through ACRA, but through the policies of insurance themselves.
Got it.
Have it written into them.
And then there's also the arbitration that's mandated by the state of New Jersey on all personal injury cases and other types of cases.
Well, look, can we start with that then? I want to kind of reference rule, I guess it's 4:21A is the rule. How does that rule work in terms of arbitration? What are you guys supposed to do?
Every county is a little bit different. Mercer County, we generally have a panel of 2 attorneys. For personal injury days or auto days, you generally have a plaintiff personal injury attorney and a defense one. Sometimes they only have a neutral. Sometimes it's a neutral and somebody else. But it's a procedure where you hear a little bit about the case, bring in the lawyers, hear a little bit about the case, they make a decision, and then if both sides agree on the number, then the case will settle. If either side doesn't like it, you have 30 days to file a de novo.
All right, so now this is just court-mandated arbitration we're talking about at this point?
Right, and one of the things, as Kevin was saying, though, is that the problem with it, if there's a problem, is the fact that while the rules specify how it's supposed to be accomplished, each county does it differently, and the process is not necessarily following what the court rule actually says.
All right.
In terms of how it's performed.
Let's go down to some real basic stuff, just in terms of who these arbitrators are. Now, my understanding, and I'm not sure if this is the court rule or the statute, is that you have to be an attorney as an arbitrator with 10 or more years experience in, automobile crashes, I guess. You could be a judge, superior court judge, or a layperson who has, again, substantial experience in this field of endeavor. Maybe somebody who'd worked in the insurance industry or something of that nature. Are you guys familiar with those requirements?
What I will say is I think it's 5 years on the attorney.
Okay.
Not 10. I'm not aware of the layperson part of it. Certainly retired judges there are retired judges that sit as arbitrators.
Right.
You are required to take a mandatory basic arbitration CLE class.
It's about a half-day course that you have to take.
Okay.
And I know, like with Mercer County, we do, it's not a recertification, but every couple of years they do give a class. It's about a 2-hour class where they try to update things.
That's all voluntary, isn't it? You don't get any money for this,
do you? There's the court rule actually it's $450. So it's in Mercer County. There's 2 arbitrators, so it's split.
Okay.
And if you sit as a neutral, which is one person, then I think it's $350 that you get as an individual.
Okay. Nobody's getting rich off of that, that's for sure.
No.
Well, what I'd like...
The people who are doing it mostly are doing it to give back.
Okay. To simplify this for our audience, because we have a lot of young attorneys who are completely, has no experience with this. I'd like you to give me a fact scenario, okay? Some kind of a crash that would be perfect for going to arbitration or would likely to go arbitration. Can you give me a fact pattern, maybe something that from your past?
Sure.
Something of that?
In the court mandated arbitration, every personal injury case is going to go through there unless medical malpractice doesn't, for instance. But in a typical personal injury case, it's going to go through that. So in an auto case scenario, just take a simple verbal threshold or limitation on lawsuit threshold case.
Okay.
Rear end collision with injuries are bulging discs.
So that's a typical soft tissue injury?
Exactly. Typical verbal threshold type of case.
So your client is sitting at the light, and let's figure out what the coverages are, okay?
Right. So my client, we'll go with my client has a minimum policy. So it's
He's got a 15 policy,
15
and
policy.
and how much PIP?
And regular PIP, so $250,000 worth of PIP.
Okay, so he's got 250 PIP and a 15 policy, sitting at the light. He's sober. It's not getting any alcohol involved. It gets more complicated. And
Might not. If you're rear-ended, it doesn't matter if you're sober or...
Well, if you're guilty
I
of
disagree.
DUI,
Yeah,
if you go to DUI, you don't get to bring a claim.
right. So let's keep alcohol out of
You have
this.
to hire Bob to make sure that
Well, let's make sure the cops don't. I actually got hired on a case like that one time. The guy was a .09 or .08 or something like that blood. He was clobbered from behind, crippled, actually. He was the kind of guy who was going to need care for the rest of his life. And the plaintiff's firm hired me to make sure that drunk driving was going to go away because it would have been a catastrophe for this guy. And the other side had a lot of coverage, too. That was the thing about it,
That's the best part of it.
But the statute, just for the people who are kind of following along at home, there's a statute on it, it's 39:6A 4.5, he would have no cause of action for either personal injury or property damage or economic or non-economic damages. Nothing. If he had been found guilty of DWI or refusal. So it's a nasty statute. For this guy, it worked out okay in the end. But go back to our scenario. The guy who hits this person in the rear and injures him.
We'll give them a better policy.
Yeah, what's their policy?
We'll give them a $100,000, 100-300 policy with 100 of... Yeah, with 100-300 policy.
All right, and does their PIP matter?
No.
Their PIP doesn't make any difference.
Well, yes, it does. If it's a commercial vehicle that doesn't carry PIP, then that eliminates the verbal threshold. So that's the only time I would say that it's relevant.
So the fact that there was a bulging disc is not going to matter if, in other words, you don't have to fight the verbal if the vehicle, like a bus or something like that.
Or a truck. The statute says it's a vehicle that's not mandated or not required to carry PIP in the state of New Jersey.
Which would be a commercial vehicle.
Right.
Or a bus.
Right.
Or a train.
Although buses, you have to worry about the whole issue with NJ Transit and the Tort Claims Act and those types of things.
All right, that's another CLE in and of itself. Okay, so here's a crash.
Tort Claims Act is also on that list with GSCLE and PIP.
All right, well, hold on.
He doesn't do Tort Claims Act cases.
All right.
That's the other one on the list.
Okay, so the accident has happened. The client comes to you and wants you to represent him on the case. Again, he's got a 15 policy, 250 of PIP. Is your first step? Let me ask you, because you were walking funny when you came in here today. Is your first step to make sure that you're going to get by the verbal threshold? Is that your starting point of your analysis?
The first step? Not necessarily. Yeah, you really don't know if you're going to get over the verbal until you see what the treatment is and what the injuries are. Generally, when someone comes to you, maybe they have emergency room treatment. They may have a couple of treatments with a chiropractor or a physical therapist.
Right.
By that point, they generally haven't had an MRI. Unless the x-ray showed fractures or they had surgery, you're not going to know right up front whether they're going to overcome the verbal. Mm-hmm. And you have to let them know that.
If you had a bulge like that, though, for a client coming in, would you be confident you're going to be able to get over the verbal?
No.
You would not be confident?
No. A herniation, I might not even be comfortable.
Why is that?
Because there's no bright line test. Like, you can't say to a jury a herniation is necessarily going to pierce the requirements of the verbal threshold. It's really what they believe is a serious...
But you're going to get to a jury in the sense that you don't think you're going to have a summary judgment situation.
Summary judgment isn't as prevalent now as it used to be like 10 or 15 years ago on the verbal threshold.
Right. To answer your question, you're going to get to a jury, but a herniated disc without surgery is still a very difficult case to win on the verbal threshold.
Right.
Well, I'm going to ask you the same question on the bulge. Guy comes in,
Bulge is even less. So I guess to answer your question, so hypothetically, the person comes to me after they've finished treating. It's a year down the road. They've finished treating, and
statute has not run yet.
Right. They come in. They've got all the medical records. They meet with me, and I see it's a verbal threshold case, and they say, "I have a bulging disc." Unless there's more to it, in other words, other diagnostic tests that show some sort of nerve damage of some sort, I'm probably not taking that case.
Would you be able to get an affidavit of merit for something like that?
Yes.
Okay.
Yeah, and it's not an affidavit of merit, but an ACRE affidavit.
What's it called?
It's under ACRE. It's just a certification of permanency, basically.
Right. Same thing, though, right?
Right. But the idea is that the difference is a certification of permanency requires the treating doctor or a board certified specialist that they refer to state that the injury meets one of the 6 categories of injury under the verbal threshold,
Right.
which a bulge is the 6th category of a permanent injury or loss of body function that will never heal to the way it was pre-accident. And the problem, so yes, you can get the treating doctor generally on a bulging disc to say that. All that does is get you to trial, where you're going to then have that doctor testifying that it's a permanent injury and that it's causally related, and you're going to have a defense doctor saying typically that it's degenerative and not related, that the bulging disc is not related to the accident. And that's the fight.
Can I ask you one real quick question, though, because you said something that's interesting, that at least in our county, summary judgment is not as prevalent anymore. It used to be every case was going to summary judgment.
Right. And
why is that?
Well, it used to be, what was this beer? I can never pronounce
Here's what it was. So it used to be Osmond versus Shaw before they did the change to the Act. And in Osmond versus Shaw, you had to show serious impact and other aspects. And courts were granting summary judgment every day on them. And then
for the insurance companies.
Correct.
Yeah.
And then when the new ACRA came in 1998, I think it was, whatever year it was, they eliminated that part of it, and there was 2 Supreme Court cases. There was Di Prospero.
You can't pronounce it either.
Di Prospero and Serrano were the 2 cases where the Supreme Court said that the affidavit was enough to, if you had an affidavit of permanency.
So so there's not going to be any summary judgment under those circumstances.
The only
very rare. I mean, I think in the last 15 years I've had 2 motions filed, and they were kind of laughed at by the court.
Were they both filed by New Jersey manufacturers? No, I'm only kidding.
No, and the other thing is, I think the only other main litigation was over the issue of that you had to have objective medical evidence, and one of the changes that was made was the doctor who was giving you the certification or who was going to testify at trial couldn't just read the radiologist's report. They had to actually read the film itself and give you the diagnosis. So they would have to say, I read the film and there's a herniation or a bulge or whatever it is. If they did not read the film, then they cannot rely on the testimony or the opinions of another doctor.
When you go to arbitration in a case like this, then is the fight about the verbal threshold, or is the fight about the money?
Both.
Both?
Right. Yes, because what the arbitrators are looking at is they're looking at it from the purpose of the arbitrators in the court arbitration is they're supposed to sit as though they were the jury. They're supposed to render an opinion based on what they think a jury would do.
Right.
So an arbitrator may look at a bulging disc case and say, if it's a bulging disc and there's nothing further in the medical records, in other words, typically there's something called an EMG, which is a nerve test that's done to determine whether or not that bulging disc is impinging on a nerve. Because you may have a bulging disc and be fine,
right?
In theory. I mean, that's not like a defense doctor. That's the reality. So if somebody just has a bulging disc, if I'm an arbitrator and somebody comes in and they just have a bulging disc and they've had a couple months of chiropractic treatment, and the best we're hearing is they've got complaints of back pain, but that there's nothing other than this bulging disc, and depending on their age even, will come into play. It's going to be a fight between myself as a plaintiff's arbitrator and the defense arbitrator, who's probably going to want to no-cause that.
Kevin, let me ask you this. 2 questions, really. A, and you have to contextualize this any way you want. What is a case like this worth? A. And B, how would you prepare to go in and arbitrate this?
Okay. As far as what the case is worth, you have to look at all the factors. You have to look at the age of the person. You have to sometimes you have to look at the x-rays to see if there's degeneration. The older the person is, the more degeneration there is, the less the case is worth. If you don't think you're going to get over the verbal threshold, and depending who the insurance company is on the other side, you may not even pursue the case. You may just punt on it because you know it's going to end up costing you more, and chances are there's not going to be a recovery. What I find is for court-mandated arbitrations, I see that people prepare less for them than they do for private arbitration and mediation, because they know that there's a high percentage of cases that are going to be appealed. So rather than putting a lot of money and effort into those cases, some of them will have their paralegal or somebody else put together the package. A lot of times they'll give it to a young associate to go into the arbitration. They don't take it as seriously as they would if they knew that it was, say, a binding arbitration where there is no right of appeal, or where you're paying money for an arbitrator to actually hear the case.
Well, under what circumstances, if any, would this scenario we've talked about wind up with binding arbitration? We'd have professional arbitrators.
Okay. Generally, it would be cases where neither side wants to go to trial. There's big exposure is one side where the insurance company would want to go to binding arbitration. Another possibility is if the parties can agree to parameters of an arbitration, a high-low. So there's a guaranteed minimum amount that the plaintiff is going to get, but there's also a maximum amount that they can get. Those are generally the types of cases that go to arbitration. So if you have a case, say, where there's multiple herniations or a surgery, and the insurance company has a $100,000 policy, they may agree to go to a binding arbitration that would cap the plaintiff's recovery to the policy limits.
But assuming that he's gotten his medicals taken care of by his own PIP, then what's the extra money for? Is that for pain and suffering?
Pain and suffering, yeah. Unless there's wage loss claim or other economic damages.
Got it. What's your sense of this? Bob, would you approach the case the same way?
Absolutely.
Okay. Now,
and I think what Kevin was saying that I think we both do is, and I think it's a very beneficial thing, is I prepare my arbitration for the court arbitration the same as I would any other matter. I don't prepare it with the idea that I'm going to go down there and just kind of wing it because everybody knows that it's going to get de novoed by the insurance company. I think it's better to show the insurance company and get the arbitrators on board by being properly prepared.
Question. Do you bring your client, or do you rely upon reports and things like that? I mean, do you want your client there to testify or not?
That's a great question. Depends on your client.
No.
Many of
Can I just tell our audience, we just got done with the discussion about sometimes you just don't want your client there because he bothers you.
So what happens is this. I, as a rule, always have my client there, but I explain to them, and I don't know that a lot of attorneys do this. I'm sure Kevin and his firm does. I either, if not meeting with them personally ahead of time, I always have a phone conversation the week before the arbitration to let them know what's happening. And the reason why is because a lot of the court arbitration, many attorneys would say, is a waste of time. And I don't necessarily think it is, but I think it's a chance to get your client prepared again for what's happening and set their expectations. But I call and I explain to them what's going to happen, and I explain to them, you're going to meet me at the courthouse. You may be sitting in the hallway, and nobody may ever talk to you. And I may go back, arbitrate this matter, come out and say, hey, good news, this is the number, or bad news, this is the number, and you've done nothing but sit in the hallway. But I want them there because I think it's important for them to feel like they've had their day, number one. And number two, it's a chance to, again, interact with them that we tend to sometimes not do as much as we should with our clients. And number three, if I'm in that arbitration room and something occurs that I think that the arbitrators want to find out from my client, where a defense attorney all of a sudden says for the first time, well, what about this? If I think I need my client to come in and explain it, or the arbitrator,
like they have videotape of your guy breaking bricks or something with a hammer.
Just happened to me. But where the arbitrators want to hear from them, because the key at the arbitration, in terms of figuring out, when you talk about value, you were asking how do you determine the value. One of the biggest things that everybody wants to know is how have the injuries impacted the client's life.
Right.
And it's easy for Kevin and I to tell the arbitrators that. But sometimes if you have a good client a client who's likable and articulate, you want them to come in. If you've got a nice, like a salt-of-the-earth Trenton blue-collar worker, I want them to come in, and I also want the defense attorney to see, again, what they're buying. And sometimes the other piece of it with bringing your client, NJM is the only one that I know that always does it.
Always brings the adjuster.
NJM brings the adjuster. So why wouldn't you want your client why wouldn't you want the adjuster, if you have a good client, why wouldn't you want that adjuster to see this really nice young man or woman?
Is your approach the same, Kevin?
It is the same, but one thing I'll say is Rob and I both sit as arbitrators on a regular basis in Mercer County. And by sitting as an arbitrator, you see the way cases are presented. And I have the benefit. I'm a neutral in Mercer County because I have a long history of doing defense work, do plaintiff's work now. And so I hear it from both perspectives. But I think what we do sometimes is after the plaintiff comes in and testifies, or after the defendant comes in and testifies and they go out in the hall, we will sometimes give feedback to the attorneys and say, I think you better settle this case. This person makes an awful witness. Or the converse is, the plaintiff is just such a likable person, you better get this case settled.
Right.
And even if the number that we put on the case doesn't settle the case, I think it gives a direction of which way the case is going to go.
But how about when you're doing your own plaintiff's work? Do you prep your guy to testify? Do you want your client to testify?
I tell my client that they have the option whether they want to testify or not, unless I think there's an issue that really has to be brought out, in which case I will tell them I want them to testify. I also set them up to tell them that when you go into arbitration, the arbitrators have already been educated on the case. They've gotten the packet of materials, they've spoken to the attorneys. So this isn't going to be a full-blown trial. This is a condensed trial. And a lot of times all they want to hear is what your current complaints are and how they affect your life.
Well, in your situation, let's say you got a $100,000 policy on the other side. What would be the things that you would want to stress to the arbitrators as plaintiff?
Really, it's the little things that make the big difference. When I was on the defense side, I used to roll my eyes because I would go to a deposition, and I would ask questions, and it seems like everything was the how it affected your sexual life.
Right.
And to me, that's just such a small part of it. So when I have a young family, I have a young mother or a young father who's injured in an accident, and I'm preparing them ahead of time. I'll ask them, well, how did it affect your life? And they'll say, oh, I couldn't do this, I couldn't do that. And then they would just leave it at that. And I would tell them, these people, the arbitrator, the defense attorney, they didn't know you before, they don't know you now. So you have to be more specific. You have to tell them exactly what it is. So I would say to them, can you get down on the floor and play with your kids if you have little ones? Oh, no, I can't do that anymore. Well, you didn't say that. Or with a woman, I can ask her about, and I don't want to sound sexist, but I would ask them about, do you have problems with doing the laundry? Do you have problems with picking your child up and putting them on the diaper table? Do you have, and by just sitting down with them for a few minutes and reminding them, it's not coaching, it's reminding them of the things that they didn't even think about.
Right.
The other thing is, a lot of times I'll tell clients to keep a pad and a pen, and anytime they have a question or anytime they think of something, write it down, because in the spur of the moment they might not think of it, and then they leave your office and they're like, oh, I forgot about this or that. This way they have it all in one place and they can think about it.
So what would you need to get this case up to $75,000 or $80,000?
Depends on the injury.
With our bulge.
Getting a bulge, unless you have a kid that's like 12 years old, who, young kids shouldn't have bulges, although if you get the right defense doctor on the stand, they'll tell you that the aging process starts from the day that you're born, so you start deteriorating after that.
You need a 12-year-old girl with a bulge and facial scarring. That's what you're telling me.
Well, no, facial scarring, that could be worth a lot more.
Right.
We were just talking bulges. The real issue is when I started practicing, and haven't been around that long, but 1990, MRIs weren't in big use. So back then, if you were diagnosed with a bulge or a herniation, they were big money cases. Now that everybody gets MRIs. All you hear is, well, most people are walking around, they have herniations or bulges in their back, they just don't know it. The general population has this or that. So you have to prove that, or you want to show that this isn't just a routine bulge that the person has. You want to show, like Rob said, that it's pressing on a nerve, that it's causing radiculopathy, radiating pain, something like that. That they had to go for epidurals because they just couldn't stand the pain anymore.
Right.
Right. So unfortunately, it's two things. So the treatment, the epidurals and different types of medical treatment for a bulge is one aspect that a jury looks at, and that the insurance company looks at in terms of valuing a claim, whether right or wrong. So it's sometimes there's more treatment than you would expect because that treatment does build the case in some respect. But the second piece of it is, the most important part is the witnesses and the testimony. So as Kevin was saying, you want to have, when you have that young family, maybe you have a neighbor who used to see the dad rolling around on the front lawn with the kid and now isn't. You need compelling testimony. It's just not enough for the plaintiff to say, my back hurts, and a doctor to come in and say it's a bulging disc.
Bob, I don't want to be presumptuous here, so you straighten me right out if I say something out of line, all right? But just to recapitulate for 1 second, this is mandatory arbitration in these types of cases, okay? And my impression from speaking to you about these cases over the years, and I guess I'm mistaken, is that you generally think it's a waste of time because you don't settle the cases out all that often, and either side can get a trial de novo out of it. Is that fair for me to say? I mean, does it have any utility?
It is fair to say that is how I look at the process on a somewhat daily basis, that we're going down there. It's very rare, I find, it's very rare that a case resolves based on either an arbitration number or what happens at the arbitration.
Why is that, though? Because, I mean, the whole purpose of it is to try to settle these cases.
Because the insurance companies almost automatically, some of them have, I think, have had their de novo form filled out before we even arbitrated. I mean, they de novo them so quickly.
But shouldn't there be a sanction for that? I mean, they're not really dealing with this in good faith, and it kind of defeats the whole purpose of the program.
Absolutely. I mean, if you ask me, absolutely, they should say, or there should be some sort of an opt-out. If Geico wants to take the approach that they're not going to pay, then don't make us go through the arbitration.
Well, Geico would only have a 15 policy anyway. Kevin, what? I don't mean that. Has that been your experience? Do you feel the same way?
I find that there's a very high appeal rate, and I don't think that arbitration in the court system necessarily gets cases settled, but sometimes it does get the parties to start talking.
Right.
And sometimes they're talking at the arbitration, which the AOC doesn't really like, but it's the reality of the situation.
Why wouldn't they like them moving closer to settlement?
Because the AOC wants it to be a very neutral process, and they really want the attorneys to come in, present their cases, the arbitrators to call it, to announce their verdict to the parties and be done with it.
Right.
And in the real world, well, first thing you have to know is a lot of times when the arbitrations take place, the insurance companies haven't even looked at the case yet. Mm-hmm. So that's one impediment to getting the case settled. Sometimes the attorneys are very realistic, and the clients, whether it's the insurance company or the plaintiffs, are unrealistic. So sometimes the arbitration process can be used sort of to send a message to one side or the other about this is the value of the case or the case should be settled. When I sit as an arbitrator, I write out very lengthy arbitration awards because I want the parties to see the thought process behind how we came up with liability or how we came up with damages.
But so in our case, if somebody came in and wanted the policy surrendered, that would be unreasonable given the facts that we've talked about in our scenario here.
Right, and generally they don't come in with a settlement demand because it's not a settlement conference or a mediation. Arbitration is more, like I said, you're more of a neutral hearing the case.
Well, I want to come back because I have about 5,000 questions for you guys, but the one thing I want to ask you is about the process for de novo. Either side can get de novo kind of automatically, right?
Well, you have to go through it. You have to do something.
What do you have to do?
Within 30 days, you have to pay $200 to the state of New Jersey.
Where am I going to get that kind of money?
To the state of New Jersey, and you have to serve it on your adversary and file it with the court.
What's the process of de novo?
It's a form that says...
No, I don't mean that. But what happens when you go to Superior Court?
So you de novo it, and then usually in Mercer County, I think it's 8 to 12 weeks from when it's that they receive the de novo, they schedule it for trial. Doesn't mean that's when your trial is going to be.
That's when the court's at full strength and we have all the judges and
They schedule it for trial, and they usually schedule, in Mercer County at least, they schedule a settlement conference a week before the trial.
Okay, so the de novo is actually your trial by jury.
Yes, right. When you de novo it, you're requesting your trial by jury.
Okay. Do many of these cases get settled at the settlement conference right before the trial?
I guess it depends on it's very case specific.
Okay.
I find, and that's where the arbitration award sometimes comes into play. You were talking about whether I think it's a waste of time.
Right.
My feeling on arbitration is on a case where, on a bigger case, or in a good case, arbitration can be helpful because sometimes we'll say to the adjuster as we're negotiating or discussing settlement, you know what, we need to let the arbitrators call it because my number is really high, theirs is low, but we all agree that it needs to be resolved. They're willing to pay, we're willing to settle.
It's not a question of if, it's just a question of how much.
Trying to figure out the amount, and sometimes we need to go down there and have Kevin say, this is the value, and it causes my client to become more realistic.
Okay.
Hopefully it's the other way around. It causes them to be more realistic, but somebody's got to be more realistic, and that helps get the matter resolved.
I'm gonna ask then the two of you to share some secrets, okay? And Bobby, let me start off with you because Kevin's really in kind of a unique situation as a neutral, okay? You're definitely not neutral, are you?
No.
All right. How in the world did you get
But
involved?
fair.
How in the world did you get involved with this mess?
In which respect?
Doing
personal injury or being an arbitrator?
Being personal injury is too disgusting. I wouldn't expose our audience to that.
Here's why I do the arbitrations. So first of all, again,
because you get the money for it, right?
Right. That's going to makes my week.
That's part of his retirement.
Here's why I do it. Because for whatever reason, the insurance company attorneys are very happy to act as arbitrators. I think it's because they actually get to keep the money separate from their salary as attorneys. I know that's probably not fair to say, but I think that's part of it.
Now, these staff people, are they
usually? Well, it could be anybody, but there's a lot of staff counsel.
Like my brother's, he has a defense firm. All they do is
right. So these guys, they're in house for their staff counsel with they're at a captive law firm doing defense work. But
would it also be private law firms that just do defense work?
Yes.
Okay.
But there seem to be more defense attorneys that act as arbitrators and defense attorneys that act as neutrals than there are plaintiffs' attorneys. And that's a real problem because you could potentially run into, in Mercer County, a panel where you have a defense attorney and you have a neutral who did nothing but defense work. That's based on how it's set up today.
Well, how many people are on the panel normally? So 2 or 3?
Two.
Two.
It's 2.
In Mercer.
In Mercer.
Right.
So, and again, that's what we're saying. So I think the rule says it's supposed to be 2, but some counties just do 1, and that's just the way it is. So each county does it a little bit different, but in Mercer, it's a 2-attorney panel, and it's supposed to be 1 plaintiff, 1 defense, or if they can't find somebody, you have a neutral with one or the other, or a neutral.
It's like having 1 Democrat and 1 Republican, basically.
Exactly. You can imagine how well that works. So anyway, so what you have is the panel. So I started out doing it. First thought process was, you know what, pretty fortunate someone to give something back, and this is something that they need people to do it. So I'll do something good and volunteer to do this. So that was the initial reason. The second reason, and I think the most important reason why I do it, is because they need more plaintiffs' attorneys to do it, to balance things out, and to make sure that the arbitration results are fair. So I encourage all the time. Every time I see a plaintiff's attorney in Mercer County, I tell them, you need to apply.
Let me just ask you a real question, because this wouldn't apply to Kevin. And, after you've heard all the evidence of the case and looked at all the submissions and everything else, you meet with the other arbitrator and start talking about it?
Yeah, so let me take you through the process. So we'll take you through an arbitration.
Well, I want to hold off because, again, we're going to discuss this in the context of you being a neutral.
Okay.
You don't have anybody to help you. You're on your own, right?
That's right.
So what do you do, Bobby?
So so when you do it as a neutral, it's just you sitting alone? Or are you
Depends.
usually with somebody?
A lawyer's answer, it depends. Okay, so what happens is...
I like that, by the way. I got to write that down.
There's-
It depends.
That's a lawyer's answer. There is a roster of plaintiffs arbitrators. There's a roster of defense arbitrators. There's a roster of neutrals. And I'm an emergency arbitrator because my office is directly across the street from the courthouse. So when somebody doesn't show up, I kick in. So what can happen is on one day, there may be a defense attorney who is not available. They'll call me as a neutral, and I'll be sitting as the defense arbitrator. The plaintiff's arbitrator is not available, plaintiff's arbitrator. And then there's times where I just sit by myself as a neutral.
Right.
For me to sit as a neutral, the parties have to agree to have the case heard by a single arbitrator. So, and I have to indicate on the sheet that the parties agreed to a single arbitrator. So that's what I do.
Do the cases take a shorter period of time when it's you by yourself as opposed to having two individuals there?
If I argue with myself, it would take a really long time. But
Right.
The presentation doesn't make a difference. It's just
There's no rules of evidence or anything like that. You're just getting whatever reliable evidence you
Yeah,
have.
we generally don't apply the rules of evidence. In fact, I know like the police report generally comes in an arbitration, which it wouldn't in court.
Right.
It's a lot more laid back, even though we swear in the witnesses and they're supposed to tell the truth. It is more laid back, and probably more does come in. They allow medical bills sometimes to come in, which they wouldn't in court.
Right. So just to take you through one to do it, because there's several different kinds of ways that these arbitrations happen, at least in Mercer County. So on a typical Thursday, which is our auto day, there's usually two panels, meaning there's...
Is there a slip and fall day, by the way?
There is. Tuesdays is the non-auto...
General liability.
How about a medical malpractice day? Do you have one of those?
There's no arbitrations in medical
There's a
malpractice
commercial
cases.
day, which is Wednesday, I think.
I think.
All right, wait a minute. I got to write this down. This is getting confusing.
I'm on
You have
the
a commercial?
I'm on the commercial panel, too.
So am I.
You have commercial?
But I
So
never
you
do
can
it.
hear lemon law cases and
You have auto, right? You have slip and fall.
no, it's general. It's
So
really
there's
general liability.
I just call it general personal injury.
General PI.
Non-auto personal
Non-auto.
injury.
Yeah, it's non-auto, actually, is what I think it says.
All right. So you got non-auto, right? Commercial, auto.
And that's it.
All right. Well, no. What's this? Why no medical malpractice?
Too complicated. Too complicated, too complex. Same
Wow.
thing. In fact, products liability, I guess, would fall on the Tuesday day.
You
the
can opt
non-auto,
out.
but you can. I think it's easier to opt out. You just have to file a certification saying that it's complex and
Isn't it like a Roman numeral 3 type case that you can
whatever it is.
opt out?
But
Yeah.
there's a way to. But so on
Yeah,
a
take us through it.
So a typical Thursday, you have two panels. So there's two different room like this. They're just little room in the courthouse on the third floor, table set up, and you have one panel is going to be Kevin and a defense attorney. The other panel is going to be me and a defense attorney. We get a docket sheet that tells us what cases are going to be heard, because the first thing everybody's doing is looking, making sure I don't have a conflict. The defense attorneys, more than the plaintiff's attorneys, are looking to make sure that, if I'm sitting with an attorney from the Remutual, they need to make sure that none of the cases they're hearing, the Remutual is on the other side of it.
Right.
Which actually happens a lot, and that's why as a neutral, say I have an NJM attorney, there's an NJM case, they can recuse themselves for that case. I could hear it by myself as long as they agree to it. Otherwise, they have to go across the hall and wait for the other panel to be done in order to start their case.
Got it. How many of these can you do in a day, by the way?
I think usually there's like, but there's
6 each
usually
room?
like, I'd say between 12 and 15 total.
And you're not getting paid per arbitration. You're getting paid for the whole day.
You get your
half day.
$225, and that's whether you start at 9. You could go 9 to, the worst I think I've ever gone was 9 to 1. I don't think I've ever gone past
That's probably illegal. I think you're getting less than minimum wage.
But most times you're done by noon, I would say.
So walk us through it.
So you have two different panels. And then, so the first kind of case that comes in is a case where the lawyers have kind of talked already and sort of know what they want to happen. So they come in, and I say this is not how, as Kevin pointed out, not what the AOC says and not what the rules say, but this is practically one type that comes in, because there's different types. So one comes in, you have the two attorneys come in, they say hello to everybody, and they say, and they kind of say, we already know what you want to do, can you just put a number on it? And they've already decided amongst themselves that they've already decided on the number even sometimes. And all we're doing is pro forma, making an arbitration award based on what they both have decided they want happening. And again,
What purpose does that serve?
because they've decided that this is what they think between the attorney on behalf of his client and the attorney on behalf of the insurance company. They think this is the number that's going to get the matter resolved. So the insurance company attorney may say to them, look, if you want $15,000, let's write the ARPA award at 20, and I think I can get you your 15. The adjuster needs to see a number like that.
Got
And
it.
sometimes it's from our perspective, we have clients who just have these unreasonable expectations of what a case is worth. I'm not saying we're always right, but we kind of know the general area of where a case should settle. We also have a feeling for what the insurance company is willing to pay for it. So if our client is asked for $100,000 on a verbal threshold case that they're not going to get over, and I know that I can settle the case for $15,000, which is probably closer to what it's worth, that's where these discussions are very helpful.
Got it. So there is some utility to this process.
In that scenario. So that's one type of a case, and that one's very quick and easily done. Then there's other ones where the attorneys come in and they're fighting over liability, they're arguing over everything. And those are the ones that take us all morning to deal with, because in that kind of a case, the process is a little different.
Or the consolidated case with a Spanish interpreter, where you have multiple plaintiffs, multiple defendants, and you can be there all day.
Sometimes it takes a lot. So you have the case where it's contested, and the two attorneys have basically decided we need an arbitrator to, just like it's going to go to trial, so let's have the arbitrators do their job, so to speak. So they come in and they hand us a packet, depending on how thorough they are. For instance, one of the local firms here has them bound in a beautiful
color
binding
copies,
with color copies and exhibits and almost like a PowerPoint mixed in, really, really well done. And I think they think that the more, the bigger, and it's almost like when you wrote a book report as a kid. If you had the fancy binder, you got an A. I think they think that they could get a bigger number with that, but they give us these binders, and we read through it. And while I'm reading it, I have an attorney talking my ear off usually about their case, and I'm trying to listen to them, but also read everything, because I want to read everything that they give us. So the attorneys come in.
Let me just stop you for 1 second. One of the important things that I find is, and we're not going to mention the firm, but the firm that he was talking about, they actually give you a summary and they highlight the important things that they want you to know, as opposed to some firms that'll come in and just throw in a stack of medical records that thick that they expect you to page through and find out what the
they want us to do their job for them.
Right.
Sort of like in the municipal court setting where defense attorneys come in and expect the prosecutor to tell them what their deal is. It's very similar, that there's some very lazy attorneys that just give everything.
Well, it seems to me it's just pure advocacy. I mean, if you want to be an effective advocate.
But that's what we started out saying, that's the difference, is that's why that's where the value is. And that's
it's preparation in addition to presentation.
But we've learned, and I think that's probably what Kevin was saying, alluding to earlier, is that by sitting as an arbitrator, I've seen and learned and seen so many what I consider to be poorly presented cases and attorneys that don't know their files and are unprepared. So it makes I learn from that what not to do, and it really changes so that I over-prepare, because I look at it as though, and by the way, my arbitration packet, goes right into my trial notebook when I'm trying a case. It's got everything, it's done. The arbitration is like a mini trial for me. It gives me a chance to prepare for trial that I know is going to happen anyway half the time.
Are you the same when you are with these cases?
For these cases, yes, and it was reminding me that when you do private arbitration, the preparation and the presentation are so much more important.
Because of the binding nature of it?
Yeah. What I find is, unfortunately, the court-ordered arbitrations last anywhere from 15 minutes to maybe half hour, 45 minutes tops. Whereas when you're doing private arbitration, you can be talking hours, days, weeks, depending on how big the case is. And your number one job is to educate the arbitrator so that they know that you know your case, that they know your case, and they can be an advocate for you when you present your case.
Can I just change the topic here real fast, because you said something that's got kind of my interest piqued. I know that if I were in a situation where I had to go to binding arbitration, I would want to go get a Superior Court judge, a retired Superior Court judge who is familiar with this type of litigation, and I know who would be literally a neutral and detached person who would decide the case based on law and evidence and nothing else. Like Neil Schuster type person, okay? What do you think about that in terms of use for private mediation?
I think there are some judges that are good. I think there are some judges who I wouldn't even think about going to. I personally have a preference. I'm not going to name the person, but there's an attorney in Mercer County, defense attorney, who is fantastic. And the reason I choose him is he not only is prepared and knows the case as well as you do, but since I'm usually doing plaintiff's cases, I can get defense attorneys to agree to this person because he is a defense attorney.
Is he fair?
He's very fair.
You know
who I'm talking about.
I use him for my mediations, and I have found him to be better than the retired judges that I used to use.
Got it.
The last couple I've used him for, I think he's fantastic.
And you have to also understand that some of the retired judges are somewhat removed from what the value of cases are, or the types of cases, whereas a practicing attorney who's doing this on a daily basis and having to value cases for the insurance company may have a better idea of the value of a case.
Yeah, you and I get into this discussion sometimes when we talk about additors and remittators in the Superior Court after the trials. And many times you'll have a judge there who has no background in doing this stuff.
Well, that's one of the biggest problems is you have today, and it didn't used to be that way, but today it's so much more politicized, the judges, that you're getting a lot of judges that either never tried cases or never practiced in the areas that they're judging, or acting as judges in, so it makes it very difficult. And you have judges with their biases. You have, a judge who did insurance defense work and then goes on the bench is jaded.
Yeah.
Right.
I mean,
you hope they're not, but they're jaded.
No, but there's a judge who's on the bench now. He's not on the civil side, but he did a lot of NJM work. So if and when he retires and he decides he wants to do ADR work, I don't know that a lot of plaintiffs' attorneys are going to want to agree to it.
Well, let me put it this way. Would you guys want to have a jury of 6 accountants?
Having been an accounting major?
No. I mean, I'm talking about CPAs. You want to have 6 CPAs on your jury and you don't plaintiffs' work?
If I have a really big wage loss claim, I do.
All right. So we've talked about court-mandated arbitration now, and we're really kind of in the middle now of private arbitration, which is usually going to be binding. I mean, that's what the arbitrator says. That's the parties you're going to live with. Is that pretty much it?
Well, that's the difference when you go to ADR between arbitration and mediation. Arbitration is of a binding nature,
right,
although you can set the parameters however you want for arbitration. Mediation is more bringing the two sides together.
How is it, though, that you guys can move from, let's say in an automobile case, how would you go about moving from court-mandated arbitration to private arbitration that's going to resolve the case?
I'll defer to Kevin on that, I guess, initially.
Okay, so generally, arbitration cases that are done outside the court are cases that tend to be larger. Maybe there's not as much of an issue on liability, or they do put up a defense to liability, but it's not a very good defense. And then the damages are where it gets fought out. We had a fairly large case a couple of years ago where a pedestrian was hit by a doctor up in the Princeton area. And it was a type of case where because of issues of lighting and other things, we didn't know if a jury would quite understand everything. And we thought going to our mediation would be a better way of doing it. The other thing is there are certain prejudices or biases that come out, meaning are eliminated when you go the ADR route, such as you have a client who's undocumented. Whether or not that comes in a court case is questionable, but when you go to ADR, it's not even considered.
Right.
So that's a situation. Or you have clients who are working under the table for a couple of years. That might not be something that you want to bring out in a courtroom. But when you go to ADR, you don't have the same concerns about bringing out that kind of information.
But are we talking about ADR in the context of binding arbitration, or are we talking about it in terms of mediation?
Either.
Well, I want to talk about it just in terms of binding arbitration for a second, okay?
So generally, what I find in binding arbitration is the insurance companies want to limit their excess exposure.
Right.
That's usually the most important thing. They want to make sure that whatever the decision is, it's within policy limits. So depending on the size of the policy, they may cap the plaintiff's damages at the policy limit.
Right.
Now, for me, that cap, of course, is going to require a floor. meaning my client will walk away with a minimum of X. And the lower they want to bring the cap down on the top, the higher I want to bring the cap up on the bottom.
Right. So how do you guys determine this? Do you meet ahead of time?
It's part of negotiation.
Right.
I'll give a proposal to the defense attorney. I'll say, I'll agree to a binding high-low 15,000, 100,000, or whatever the proposal is. The most important thing I've found is making sure that you have the right neutral, because if you don't, one way or the other, you get screwed.
Well, somebody should walk away unhappy, I would think, at the end of the day, since this is binding arbitration, right?
Not necessarily unhappy. I mean, a lot of times the insurance company's happy just to have that cap in place.
Right.
I know that there's certain insurance companies that will agree to go on a high-low to a jury trial. So, because they're afraid of excess exposure, they're afraid of going beyond their policy.
It's a lot easier to me to go through binding arbitration than go through all that mess.
It's actually, it's hard to say. I agree. I think
it might be fact sensitive. They might feel they get a better shot with the jury, I guess.
One of the differences is when you go the ADR route, usually you don't have to bring your experts in. So
just use reports.
Right. So it's a lot less expensive that way.
Right.
Going to a jury trial where you have maybe a medical expert, a liability expert, you could be talking $8,000 to $10,000 of costs.
And and you got to hope the jury understands what they're talking about too.
Right.
Bob, what are your thoughts
about?
The
first question is, so you're talking when you do the binding arbitration, you choose an arbitrator, they choose an arbitrator, and the two pick a neutral, or do you agree on? Are you normally doing a 3-panel arbitration, or are you negotiating that?
All the ones I've done have been one party, a neutral. But I mean, through our office, we have done 3-party arbitration. 3 arbitrator panels.
So the critical piece then is who the arbitrator is. If you're doing one arbitrator.
When you do the UM again, that's really contractual now. It's not mandated.
I haven't done one in 15 years.
But when you do the UM arbitrations, generally the plaintiff's attorney picks a plaintiff's arbitrator, defense attorney picks a defense arbitrator, and then the 2 arbitrators are supposed to pick the neutral.
Got it.
That's how that.
But for binding arbitration, you're talking about.
Well, that's for UM.
Okay.
And the way UM policies read is typical. The policy reads that if the award is under 15,000, it's binding. If it's over 15,000, either party can request a jury trial. So you can imagine a situation where you have a case that's worth $15,000, and you're trying to get them to all award $14,999.
Something tells you guys have done this together. Okay. So there is some utility to selecting a private arbitration, but you got to make sure you get the right people there. Okay.
Right. So
and I imagine those cases are handled a lot more professionally, with a lot more attention to detail and a lot more of a sophisticated presentation of the proofs.
And that's what I was getting at before. Like when I do private arbitration or mediation.
As an arbitrator?
No.
Oh, as a litigant. As a party.
Yeah. For me, the first step, the most important step, is putting together an arbitration package or a mediation package that's going to educate the neutral so that they understand my case and that they know I'm prepared for this case.
Got it.
A lot of times you'll see neutrals who know the case better than the attorneys do. They read everything. And those are the good ones to have, because not only do they know the case, but they can point out each side's flaws and strengths to the other side.
Does the insurance company, they take the same approach on the binding arbitration in terms of level of preparation and professionalism?
I've seen both.
Okay.
I always approach it. I'll do a very extensive memo if I want to put in exhibits and photos and stuff. For medicals, you want to highlight what it is you want them to see. Again, unlike the court arbitration, you don't want to just stick a stack of medical records in there and hope that the neutral is going to read everything. You want to point out to him exactly what it is you want them to see.
Would you ever go to one of these arbitrations without a high-low predetermined?
I have proposed it, and the insurance companies have not taken me up on it. I was negotiating a case not too long ago where the adjuster kept telling me that my case stank and it wasn't worth that much. And I said, okay, let's just go to arbitration. Let the arbitrator call it, no high, no low, and they wouldn't do it.
Yeah. Too much upside risk for them.
Well, I think it's also, so and again, I do less of these binding arbitrations for different reasons, for various reasons. But one of the things that the arbitration does is, number one, it gives finality. Number two, it allows you to keep your costs down.
It speeds up the process too, though.
And it's also it's a risk it's risk control.
Right.
So for the insurance companies, I think the insurance company likes the arbitration process because, again, what they're focused on, because I get it offered all the time in a jury trials, all they want to do is make sure that they're capping their liability and exposure at the policy limits.
Or under.
So that their insured is not exposed. So when you go to court, if you're going to have a trial, they almost routinely say, we'll stipulate the liability if you agree to cap the policy
limits.
And we say no.
Right.
Because there's no reason to do that.
Yeah, if it's a rear end hit,
but they do it,
they're not giving you anything.
But they do it all the time, and I think a lot of attorneys just say, oh, that's great, one less thing I have to worry about.
Mm-hmm.
Most of the time, the insurance companies, when they realize that you're not going to agree to the cap and limiting their exposure, they then come up with money.
But it seems to me, Bobby, that one of the big things from the plaintiff's perspective is that, especially if you have a high-low, he knows he's going to get something out of it, A. And B, whatever's going to happen is going to happen a whole lot faster than waiting to go for a jury trial.
But potentially, I guess, at the point where you just...
And oh, by the way, the expenses will be significantly less as well.
I think that's the biggest, the single two biggest things are, or it's finality. It's the fact that if you negotiated a high low, then you're going to get something, regardless of how it turns out. And the biggest thing is, again, it's not having to bring your experts in, which we've talked about before. In the court process, they have expedited trials, which is very similar to a binding arbitration, except you have a jury is your arbitrators, where it's all based on the records that are presented. We've never lost an expedited trial because when your case is presented by the records, the plaintiff has the advantage, I think. The plaintiff has more than just a report from a doctor. They have treating records. They have an emergency room record. They have the treating records. They have an expert report. They have so much more, and they don't have to have their doctors come in and testify, so it's all read.
Right. I was just going to think, let me just ask you guys a question and just use round numbers on this. Let's say that on our little accident case that we're talking about, let's say that there's $50,000 on the table. That's what the case is worth. So if you go to a binding arbitration and they offer you $50,000 versus trying the case and getting the jury to come back with $50,000, I would think your expert fees are going to eat up so much of the recovery
on a trial,
that it's really, you'd have to be insane not to go to a binding arbitration under those circumstances if you're going to get the same amount of money at the end of the day.
Well, you don't know you're going to get the same amount of money.
You don't. That's the problem.
That's the problem.
But you do. But you know it if you have somebody like you who has a feel for how these cases are going to go.
No. You know, the neutral that Rob and I have alluded to. Whenever I have a client in and I'm having trouble getting them to accept a reasonable offer or something like that, the comment he always makes to my client is, do you want a jury of 12 people who weren't smart enough to get out of jury duty decide your fate? Mm-hmm. And that's what it comes down to. You never know what a jury's going to do. Right. I think Rob can attest to the fact that we've lost cases that we should have won and we've won cases that we should have lost. And you get a feel sometimes. Rob, I'm sure you know that when the jury's not looking at you when they come back in, you're dead. You're done. You can have people, they're smiling at you and they come back and the number is like a fraction of what it should be. You just never know what a jury's going to do.
Mm-hmm.
Yeah, absolutely.
Let's talk about mediation for a couple seconds, okay? Under what circumstances would you want to mediate, and why is mediation better than just court-imposed arbitration?
I would mediate any case that the defense wants to mediate.
I agree.
Think mediation is the greatest tool that's out there. And I know the old-fashioned trial attorneys might say otherwise, but I think that they say that, But
Well,
at the end of the day,
you're a new faction trial attorney. Why do you?
I guess I'm old now, but I still consider myself a young attorney. But there's so many attorneys that pontificate and thrust their chest out and say, "Oh, you got to try your case. We're trial attorneys." The reality is, when you mediate a case, you control every aspect of it. You can walk away and say, "You know what? I'm going to have my trial," or you can get the case resolved if you get the numbers to where they need to be, and your case is over, and you have the certainty and the finality, and you move on.
Well, how do you get to the point where you're mediating a case, though? How do you get your adversary to get you to join in the process? And what's the difference between this and arbitration?
That is always the trick, and I don't know if Kevin will agree with me, but I find with mediation, the two keys to mediation are getting the defense attorney to think it's their idea to mediate, and also getting the defense attorney to think that the person who's the mediator was their choice. Because I know that if I call a defense attorney and say, "Hey, why don't we mediate this case?" If the defense attorney says, that's a good idea, he thinks if I've called and asked him to mediate that I think that my case is weak and I'm willing, I want to get it resolved. That's why I want to mediate it. That's, I think, the first psychological component to it. The second is, if I say, "You know what, why don't we use Judge Schuster," who they would have used if I hadn't said it, they're going to say, "Oh, well, he wants Judge Schuster, so we can't use him." So the idea is how to trick them into thinking that the choice of mediator is theirs, or letting them feel like they're controlling that.
Kevin, do you agree with it?
To an extent, yeah. I find that there's certain types of cases that are more ripe for mediation than others. Nursing home cases, I find, are very good for mediation. And the reason why the defense wants to go to mediation on a nursing home case is they're afraid of the emotion that could happen in front of a jury. Mm-hmm. They don't want a jury to hear that an older person was abused or neglected, or
You don't want the police to hear it either.
That's true. I also find construction cases, because they tend to be a little bit more complicated, more expert-centered, that those are the types of cases that tend to go to mediation.
And I think what he's just alluded to is really, I would summarize it a little bit differently. Cases with potential for big damages, big recoveries, are the cases that get mediated. Small cases generally don't get mediated because everybody's going to take their chances.
Just in case I run into my brother sometime, what about medical malpractice cases?
I just went through with Judge Schuster we're on the third round of mediation, and on a pretty significant medical malpractice case, and the end result of it is after 3 mediation sessions and numbers that were pretty significant numbers going back and forth, everybody called and said, "Hey, we starting trial, 4-week trial in January." So the idea is it's a great idea for a medical malpractice case, but again, it requires reasonableness.
Consent to settle.
Right, reasonableness on all sides. And in a medical malpractice case, as Kevin's saying, is the defense doctor generally has a consent to settle clause in their policy. So they're involved as well, and they may not. Some doctors just don't want to consent, and that's where your brother has his work cut out for him.
Well, yeah, I think his case is in his state. I don't think they settle anything because the doctors, there's like a 3 strikes law in Florida. They lose their license to practice. They have 3 judgments against them or something like that, and they just won't settle. It's too devastating for them.
I will tell you,
so they all get tried.
I will tell you one thing in Florida, just because you mentioned Florida, instead of having mandatory arbitration like we have of personal injury cases, they used to, at least when I practiced down there, they had mandatory mediation of every case, which was a better process again.
So how often are you successful with mediation in the sense that the parties were able to, resolve the case?
I think this medical malpractice case may be the only case that I have not resolved that mediation. I've even had, and I've told you the story with the defense attorney we're talking about as the mediator. We had a case where my client wanted, I think I told you, so my client wanted $240,000, and the defense came up to $237,500.
You better put in the last part out of your own pocket.
We walked out.
Oh, wow.
We walked out, and the attorney called me while I was in my car saying, "You didn't just walk out. Are you crazy?" And I had a client who just was, I was going to just say, "I'll give you the money," but they were principled. That's what they wanted. The next day, we settled it for, I think, $239,000. It's every case that goes to mediation, at least that I've had.
What what Rob was saying is pretty much the same experience I've had. Of the cases I've taken to mediation, I've never not settled them.
So can I rephrase the question then? Would you say that there's an extremely high statistical likelihood that the case will settle if it goes to mediation?
Yes.
I would say yes, and the reason for it is because at that point, the attorney, the plaintiff's attorney, and the insurance company are putting money out of their pockets to get the case settled. So there's a desire on both sides. When you go to a settlement conference at the courthouse, you have a judge there. You're not paying for it. The judge could put whatever number he wants on it. You go. If the insurance company hasn't even looked at the case yet or they haven't valued it, you're just wasting your time. You hope that by the time you go to a mediation, ADR, arbitration, whatever it is, that both sides have evaluated the case and they're there to settle the case.
What is the investment the insurance company has made
as far as
in getting ready for mediation?
For the mediation, it's the cost of the mediator.
Right.
And the defense attorney for the
right, and
preparation and
but I guess I'm always thinking of captive attorneys.
Would they have the experts come in and testify during the mediation, or just use the reports?
Mediation is not even reports. So mediation, you're not really presenting testimony or evidence in a typical mediation. So, and just to backtrack, so what Kevin was saying is absolutely what it is. When you go to mediation, both parties have decided the case needs to be resolved, and both parties, the insurance company has already concluded that they're going to be paying something meaningful. May not be what the plaintiff wants, but they're going to pay something meaningful. You don't go to a mediation and go through that process if the insurance company isn't prepared to pay something significant. Likewise, the plaintiff's not going there if they're not willing to be reasonable as well. And
that being said, and like Rob just experienced, you also have to be prepared to walk away from the table if you're not happy with the way it's going. I had a case, the pedestrian case that, it was a construction case. I went down to, I think it was Chester County, arbitrated the case, or mediated the case, and they just were not coming up with any money. We walked out.
Because you're wasting your time.
Right. We walked out. We ended up going back to mediation, but before we did, I told them that they had to put more money on the table for us to even come back and get started. And the case eventually settled for a very good number. And the case that you and I did the seminar on recently.
Oh, for the super case.
Right. That case mediated twice, a year and a half apart, because the very first time the defense wasn't ready and the insurance company wasn't ready, and it was really a wasted opportunity.
But at the end of the day, did your the money you got on the case, was it close to what the mediator had suggested?
Well, the mediator doesn't suggest a number. The mediator is just there to bring the two sides together. They may give you a feel and say, well, I don't think the defense would be willing to pay more than X, or I don't think the plaintiff would take less than Y. But the mediator, unlike an arbitrator who puts a definitive number on it, that's not the mediator's job. The mediator is just to bring the sides closer together.
Does the mediator ever meet with the parties privately?
Yes.
Only all the time.
Shuttle diplomacy.
Right.
They're going back and forth, back and forth.
The mediator acts as a facilitator, and that's it.
Settlement conferences. What is, because you have a tremendous amount of confidence the case is going to settle when you get to mediation. What is your level of confidence in terms of settlement conferences, before the trial?
It depends on the type of case. It depends on the carrier. In Mercer County, those are the two factors that come into play.
It also depends
I find most do not. The cases that I settle at a settlement conference are the cases that I think that I don't like my case.
All right.
Other than that, they're not settling.
There's also not necessarily Mercer County, but other places like I've done in federal court where the parties ask the court for a settlement conference. Down in the Eastern District of Pennsylvania, you can ask the judge if you can go to the magistrate for settlement conferences. And that I've found to be successful. I don't find a lot of times when the courts say you have to come in for a settlement conference. to be as helpful.
I've been very impressed in federal court how hard the magistrates work to settle these cases. And they put their heart and soul into it, and it's great.
I think they're terrific. I think, and it's funny that I think most plaintiffs' attorneys in personal injury cases try to stay out of federal court for other reasons that are slanted in terms of expert rules and such. But in terms of if you have a case that you want to get resolved, those magistrates get it done.
Well,
Absolutely.
you guys have changed my mind because I had the wrong impression about this mandatory arbitration, and it does have a tremendous amount of utility if you go about it, approaching it the proper way. And I hope our viewers will be able to keep this in mind. Bobby, thank you so much. Kevin, as always, thank you guys. You're both young geniuses. Thank you, guys.